obviously touched on the fact that the UK voted, to leave the EU. So, what impact might Brexit have on the future of insolvency for Europe and the UK as well? So, to discuss these topics with me today are two very distinguished panelists. To my left is Justice Richard Snowdon of the High Court of Justice of England and Wales, and further to my left, David Shinner, lawyer and partner at DLA Piper in Paris, and also barrister of England at the Bar of England and Wales. Is that right? So I will start with a general question, maybe to you, Justice Snowdon, about what you think has made the UK so successful and attractive in the past years.
Well, good morning. What I'm about to say actually echoes a great deal of what you've just heard from the Commission. In 1986, we changed our insolvency laws fundamentally in the UK. We moved from the idea that insolvency was about liquidation and selling of assets and repaying secured debt. And we introduced for the first time what we called the rescue culture. We introduced an administration process which was designed to save viable businesses and preserve jobs. We did that with the assistance of a new group of people that had never existed in England before. We called them insolvency practitioners. We gave them special powers, and largely they were accountants. They weren't lawyers, they weren't judges, they were appointed by the courts, but they were accountants. And this had a huge benefit because accountancy firms had already been well established across national borders. And we gave the opportunity to rescue businesses and save jobs to people who understood business and finance. We also did something which, again, echoes what the Commission is planning to do, which is we took a group of commercially experienced judges and gave them increased powers in relation to insolvency. I've been a judge in England now for 18 months. Before that, for 29 years, I specialized in corporate insolvency cases. So I cut my teeth on BCCI, Maxwell. Along the way, we also had Federal Mogul from the United States, Lehman Brothers, the Icelandic collapse. Those were my bread and butter cases as a practitioner. So I brought to the bench 29 years of experience of commercial insolvency, and that the same goes for my colleagues. So that when in 2000 the European Insolvency Regulation, the first European Insolvency Regulation, came into force, the UK was already very experienced as to how to best utilize that European Insolvency Regulation, because it had had 14 years of saving companies and operating through insolvency practitioners. So the English insolvency profession was able to overcome one of the difficulties of the European Insolvency Regulation, which is that it, at the moment, doesn't allow for coordination of insolvency across national borders. It focuses simply on single corporate entities, not groups. But of course, if you have a group of insolvency practitioners who are fundamentally in the big accounting firms, they have offices in other jurisdictions. You have a ready network of coordinated insolvency practitioners. And again, that allowed the English insolvency profession to take the lead very quickly in relation to implementation of the European Insolvency Regulation. And then finally, I suppose, again, picking up on what was said by Michaela, because we have experienced judges, we also have the ability of people to take rapid commercial decisions. And that, again, coupled with the ability of the insolvency practitioners to coordinate across national borders, meant that we had a very responsive system. And if I can just briefly touch on one case study to illustrate the points I've made, you'll notice I haven't spoken at the moment at all about schemes of arrangement, which I know is a very topical subject, but I will now talk about a scheme of arrangement because in a case called Rodenstock, the first case in which the English courts had really looked carefully at restructuring a European company with no base, no COMI, no establishment in the UK, all the factors that I've just spoken about came together. Now, we've had a scheme of arrangement in the UK for well over 100 years. It's nothing to do with insolvency as such. I mean, it's used for takeovers as well. But in about 5 years ago, a German company was unable to restructure in Germany because it had no pre-insolvency mechanism to do it. It would have had to go on into formal insolvency in Germany with the loss of jobs, the loss of value. It had a holdout creditor in its bank facilities, which was preventing a consensual restructuring. And it was facing German insolvency in 6 weeks. It had one possible connecting factor to the UK, and that was that the bank facilities were governed by English law. I was the barrister that presented the Rodenstock case. I did so in front of a very commercially minded English judge who saw here was a German company destined for failure with loss of jobs, loss of value to creditors. He'd been in the rescue culture for 25 years. I'd been in the rescue culture for 25 years. Of course, he would therefore be receptive to the argument that the UK court should help if it could. And we used the connection to the UK, the English law connection, as a peg upon which to hang a restructuring. And we did it from beginning to end in 5 weeks. 5 weeks. And that included 3 weeks for the notice to be given to the creditors. Okay? The decision to convene the court meeting was taken in 2 days of argument, in 2 hours of argument. The actual decision to sanction the scheme we did very thoroughly, and we did it in 2 days. But the result was that that German company was saved. So all those factors that I've just rehearsed over 25 years' experience is what has driven the English insolvency profession to offer a restructuring tool where we can, to save jobs, to save viable businesses, and return value to creditors. And that's basically what we think insolvency is about.
So would you argue actually that essentially the popularity of schemes of arrangement, I mean, companies from Spain, I'm thinking about Corte Fiel, a Spanish retailer, Apcoa, a German company, has come to the UK, Metinvest in Ukraine has also come to the UK. I mean, all of these companies seem to come when they don't seem to have any other options, when they are in a deadlock in their own jurisdiction. So do you think that maybe the UK scheme of arrangement provides them with this alternative and gives them a bit more flexibility and predictability with the outcome that they're after?
I mean, yes, we have no great plans to conquer the world. We haven't gone out and recruited these insolvent companies to come to the UK as such. I mean, the drive is from abroad. I mean, it is that companies are unable to restructure in their own jurisdiction. Or, again, the problem with the current European insolvency regulation, if you have a pan-European group consisting of companies in a number of European jurisdictions, at the moment there is no structure apart from a scheme of arrangement that will enable you to restructure that group successfully, or it's very difficult to cross national borders within Europe. It's the point Michaela made. But if a common factor that connects those companies and their debts is English law, we have said, fine, if we've got a sufficient connection and what we do will be recognized in Europe, then we're very willing to help. I mean, that's the driver for schemes of arrangement. I mean, the cases you mention are all cases where companies have found it more convenient to come to England to restructure, and where the English court has a reasonable degree of assurance that what it does will be accepted and recognised in other European member states. I mean, now sitting as a judge, I have absolutely no desire to make an order that is in vain or would be regarded as an insult in other European countries. And I want to do something which assists European companies to restructure and will be recognised in their home member state. If they come to me and ask me to save the company, to save jobs, and to save value for creditors, and I can do it in a way that will be respected in other European member states, why would I not do it? I mean, that's the driver.
I mean, David, you may have a different perspective being a French lawyer. So when we're talking about a need or maybe something that the law of whichever country we're talking about was lacking in, I think very few French companies have come for schemes of arrangement. I have two in mind. One was Zodiac Marine, whose assets were mainly in the US, and another one was Zlomrex, which was part French, part Polish. So apart from that, would you say that in France and elsewhere in Europe, you actually agree that there is a need maybe for proceedings like scheme of arrangement?
Well, first of all, I think one of the reasons that not many French companies go elsewhere is that we've got a highly developed insolvency law that includes almost a dozen different proceedings to choose from, and that we have a system of commercial courts, more specialized now following recent legislative changes, but already in the past pretty specialized, where French debtors, as a general rule, have not felt the need to go forum shopping. The other thing is that we have a series of courts of appeal that are very reluctant to recognize forum shopping. I mean, I don't know if there's anyone from Alsace-Moselle in the audience, but under their laws we have something that resembles what the Commission has proposed, which is discharge for individual bankrupts after a relatively short period. So we have had a lot of German individual traders trying to cross the border to Strasbourg or Colmar or Mulhouse, establish themselves there and get a French, I beg your pardon, discharge for their debts. Now the courts of appeal that have had to deal with that have been extremely reluctant to accept movement across the border unless it has been real substantive movement. And I think that's one of the big differences. We have a culture in which it is not up to the debtor to choose his or its jurisdiction. There are specific rules that are intended to ensure that the proper court deals with the proper case. And there is a very strong tendency to assume that where people manipulate those rules, it is in some way inappropriate. Now, couple that with a very debtor-friendly regime, which has quite an effective stay on individual proceedings, and you get a situation in which, at least from France, there is no great appetite for a debtor to start forum shopping. I've had to handle a couple of cases where people have tried to market shifts of Comey to England, and one of the reasons the directors elected not to do that is because they took advice from criminal law counsel on the issue of whether a totally artificial Comey might amount to fraud under French criminal law. The mere likelihood of a prosecution, or at least a criminal complaint, was a major element in directors electing not to do that. But I think that's a minor thing, because over the last at least 10 years, I've only seen 2 cases where people have seriously thought of shifting Comey to England. I think the real answer is that our laws and our courts are perceived by French debtors as rather adequate.
I mean, if I can just comment on that. I mean, I entirely agree with the point about the debtor-friendly nature of French jurisdiction. I mean, that's a perfectly legitimate reason why French companies should decide not to seek to restructure in England. They have their own domestic restructuring tools which are perfectly good for the job and, in fact, are desirable from their point of view. But what I do disagree with is the implicit suggestion that there's something improper about what the English courts have been doing in relation to comey shopping, forum shopping, or bankruptcy tourism. I mean, I indicated that there are two reasons that the English court might accept jurisdiction to do a scheme of arrangement, for example. One is that English law has been chosen by the parties as their governing law. That's got nothing to do with forum shopping. That was a conscious choice by the parties at the time when they took their financial obligations to choose a system of law which had a scheme of arrangement as a restructuring tool built into it. As it happens in APCOA, they changed the governing law just to go and get the English scheme of arrangement. Well, let me just tell you, I was the counsel that opposed that. Having done Rodenstock to get the English court to try and do a scheme, I was employed by the German government effectively to oppose the scheme in APCOA. And one of the reasons we did want to oppose it was that there had been a recent change of governing law, which we said was an insufficient connection. The judge rejected that argument, but we got permission to appeal from the Court of Appeal, so that question is still out there to be decided. But the comey shift, the bankruptcy tourism, I would find that equally offensive. I have no desire to approve a scheme of arrangement for a company which has artificially pretended to move its centre of main interests, or a bankrupt who artificially changes his domicile. And I'm strengthened in that by recognition that the European Union, in the new recast insolvency regulation, has included provisions precisely designed to deter artificial comey shifts and bankruptcy tourism in the presumptions that apply in relation to comey. So I don't think you'll find the English courts actually any longer, if they ever did, accepting artificial bad forum shopping, if I can use that expression.
And maybe, David, you want to comment on possible recognitions or difficulties for recognitions of international and particularly British rulings in France. Do you have examples where you felt like maybe the judge wasn't that keen to acknowledge what was ruled in the UK? And before Brexit, let's say before Brexit.
Before Brexit, well, we're all familiar with the case of Daisy Tech, which was one of the first cases where an English court sought to exercise its jurisdiction over a French company. And we're all familiar with the rather strong language used by the judge to refuse to recognize that a court somewhere in Birmingham, wherever that is, might have something to say over a company within his jurisdiction. The strong language was overruled on appeal, and the Court of Appeal actually applied the relevant EU regulations. So I don't think it's a major issue these days per se about recognizing these things, but I think Brexit will become a really major thing because many years ago I had the privilege of acting for Enron when they became insolvent. And Enron did not have any French subsidiaries. And we had all sorts of creditors trying to do action polienne, in other words, seizing the assets of various Enron subsidiaries that were within the French jurisdiction, based on the fact that the court in the Southern District of Manhattan, wherever that is, did not benefit from any recognition in France. And the initial position was quite a few creditors did manage to jump the queue and go around the stay of action in the US. And we eventually went for exequatur in front of the Tribunal de Grande Instance of Paris. And we actually tried to treat the decision to open bankruptcy proceedings as an ordinary civil decision to be recognized under ordinary civil proceedings in the absence of any treaty, or at least any treaty recognizing bankruptcy or insolvency as such. And we were successful, but it did take 6 months. And in that case, one of the reasons that we were successful is that both the Tribunal de Grande Instance and the Procureur de la République were very eager to acknowledge that it's a pretty banal, pretty legitimate thing for an obviously insolvent US company to go to a US court. I would be a lot more reluctant tomorrow in front of a group of companies with an English high court that would hypothetically no longer be European and subsidiaries in France, for instance, whether exequatur might or might not be quite that easy to obtain as a public policy matter.
Well, I understand the sentiment, or at least I acknowledge the sentiment. I would be disappointed if that was the outcome. I'll say nothing about Brexit. I make no comment about it as a decision. I'm not really entitled to in my current job. But I can say this. There is a world beyond Europe. And beyond Europe, there are insolvencies. The one thing that I think binds everybody together in the insolvency field, perhaps more than in many other areas of law, is that we all have certain common goals. If I'm judging just a contract dispute between A and B, I interpret the contract and A wins and B loses and they disappear and I never see them again. That's a very straightforward thing. But in insolvency, there's a different game to play. Everybody is interested in rescuing viable businesses, saving jobs, returning value to creditors. Those are the three main pillars of insolvency law. And wherever you go in the world, that's what people tell you. And so there has to be, I think, people have got to stop treating insolvency as some sort of cross-border inter-judge contact sport. I mean, insolvency is about more than national borders. And I think we have to get into a mindset, both within Europe and in the wider world, that actually there will be benefit in cooperation across national borders and in saving companies. And the idea that some court or some judge has a particular possession of a company and should therefore be entitled to restructure is actually, I think, quite economically counterproductive. So that from my perspective, sitting as an English judge, for example, I mean, I will be looking to make sure that if I'm asked to make an order in a cross-border insolvency case, I'm going to be very interested in understanding how that order will be viewed in other jurisdictions where the company has assets, where other creditors are based. I don't actually mind whether it's in the EU or whether it's in America or the Far East. Wherever the company has assets, wherever creditor action may take place, I want to know, if I'm being asked to make an order, what effect will that order have? Will a judge in that other jurisdiction think it's a sensible order? Will he recognize it? Will he give effect to it? And I would like to think that other judges in other jurisdictions would look at me in the same way. Because I think we've all got a much bigger game to play, a bigger part to play than the usual sort of national politics of whose company is it anyway.
David, would you like to come back on this? I mean, there are now professional commercial court in France as well.
It's interesting.
Which might make a difference.
We had experiences in France, it's probably over 20 years ago, of lots of companies changing internally their registered office just so that they could effectively select their judge. Because normally under the French internal rules, it is the commercial court of your place of registered office that is competent. And what we found is that when companies were playing games in order to select their judge, there was usually a good public policy reason why that should not be happening. And there was a decree passed, and the decree said something very simple. It said if you've changed your registered office in the last 6 months, then the old court remains competent for that period. And it did stop a large number of games that were not necessarily to the credit of the judicial system. And as a result of that simple rule, there was a lot of clarity and a lot of quality improvement. It's been around for 20 years and it's largely uncontested. There is something about a judge not being selected, but a judge being a totally impartial individual or group of individuals that is imposed on a debtor rather than chosen by the debtor. Now, that's as a general statement. Beyond that, you were referring very recently, Sir Richard, to APCOA and the change of law. There is something that, at least to a French mind, appears uncomfortable with that.
It appeared uncomfortable to an English mind as well, actually. But unfortunately, not the judge I was arguing in front of.
Because, you know, for those who aren't familiar with the case, here's the debtor with, for the sake of argument, no real establishment in the jurisdiction. All there is, let's call it a multilateral credit facility amongst a variety of lenders and a variety of borrowers within the corporate group. And that credit facility happens to be subject to a law, and there is a provision that enables one to choose a change of law. And simply in order to achieve effectively the ability to restructure under what is seen, rightly perhaps as an attractive tool, the scheme of arrangement, in a purely artificial way, in a sense, one changes the rules governing the multilateral credit facility and says, well, let's pick English law, and on that basis, let's go convince a judge. Now, Gilbert and Sullivan used to say, I think, let's hoodwink a judge who is not old or wise. I think that does not apply to the specific case in instance. But be that as it may, let's just use that little change of law and bring it into a jurisdiction that suits us, because there is a legal instrument, a scheme of arrangement, that happens to be what we think is the easiest or the most efficient way to achieve a restructuring. Now, contracts and insolvencies are part of a legal system in which legal certainty, we heard from the European Commission a short while ago, indeed the Gouverneur de la Banque de France as well, legal certainty has a lot of value. This is the total opposite of legal certainty. You're lending to a company or a group of companies in country X under law Y, and from the day to tomorrow it's going to be restructured in a totally different way simply because a commercial or a finance contract is changed. Whilst the result may be desirable in this specific instance, I suspect that there are many who will feel that what it does runs counter to legal certainty and may achieve a negative result in the long term.
Well, David, I should have had you as my junior arguing the case with me. I mean, those were exactly the arguments which we were running. To prevent some balance, I mean, of course, don't forget that the choice of, or the change of law had been undertaken by a majority which was permitted by the financing documents.
It was only a 50% majority, which is relatively weak.
You know, there is the point. However, the point is, the good thing about APCOA as a case, it does illustrate one point, which is that the English court looked very hard, long and hard, at the question of whether to accept jurisdiction and approve that scheme. We had 5 days, I think, 5 days of argument in court. I cross-examined the German expert witness who was attesting to the way that the scheme would be recognized in Germany. I mean, there was evidence in front of the English court as to what attitude the German courts would take. We said, they will be offended. The German courts won't like this, they won't give effect to it. The other side, the proponents of the scheme, said, oh, yes, they will. They'll be perfectly content with it. And we had expert witnesses, Dr. Paulus from Germany, a well-known expert, my expert from DLA Piper in Germany. And they were cross-examined for a day in front of the English judge. it was a very thorough examination. So the one thing I will say is that, rightly or wrongly, and we'll never know because the appeal was settled, the case got settled before the appeal court, but rightly or wrongly, at least the English court looked very long and hard before it just made a decision. One thing I will say is the English court is not a rubber stamp in these cases. Most definitely not a rubber stamp. It doesn't just approve whatever the debtor wants. I've given a number of judgments where recently where I have made it very, very clear that I regard my role as a judge is to go around this vehicle and kick the tires and look underneath the hood, look under the bonnet and see what's there and test whether this is an appropriate exercise of jurisdiction. If I may go back to one thing I was saying earlier, which I forgot to mention, when I was saying it's very important to have a more international outlook in these sort of restructuring cases, it goes back to something that was Michaela said again about that the Commission has made clear needs to happen. There needs to be judicial education and judicial training in these very specialist fields. And if you can't appoint your judges from some people who've had 29 or 30 years practical experience as practitioners, there are various ways in which you can assist judges to get a more international outlook. There are conferences like this. There are organizations like INSOL, like III, the International Insolvency Institute, where judges regularly meet from many jurisdictions in order to get a better understanding of what's going on in their respective countries, to have a better level of trust and confidence in other judges in other jurisdictions. So I think that whole area has to be strengthened. That's soft training. It's meeting people and understanding that German judges are normal human beings. English judges, I like to think we're normal human beings. And that will, again, assist in the restructuring process.
Sorry, did you want to say something there?
Yes, I mean, I'd like to come back to Brexit. I have the great privilege of being allowed to be controversial, which makes me, I guess, only one on this panel. And I think when we're speaking of Brexit, just because the majority of Neanderthals voted one way, is not a foregone conclusion. We've all recently seen that Wallonia, 3.5 million inhabitants, stopped 500 million Europeans from signing a jolly sensible treaty with Canada, a roughly civilized place, I'm told, that was negotiated by the EU Commission for 6 or 7 years. Now that may yet work out fine, but the reality is the commercial treaty with Canada is comparatively simple, indeed almost simplistic, when contemplating the type of treaty that would be necessary to unravel the relationships between the United Kingdom, or whatever is left of it after Scottish independence, from the rest of the EU. Now, take a few examples that are relevant to people like us who have an interest in the insolvency world. One of the issues is the recognition of civil judgments. I just mentioned it in Enron. Well, today, an English or a British judgment is effectively, with very minor exceptions, automatically recognized throughout the EU. If we had a hard Brexit, and I'll come back to it, such automatic recognition would no longer exist. There are literally hundreds of examples of things like that that would impact an insolvency case that will have to find their way into some sort of treaty that would in some way formalize the British exit from Europe. Now let's step back for a second. Let's look at Article 50. We've already established that if you want to leave the EU, that's a treaty. Based on the Canadian experience, it's almost certainly a mixed treaty. Therefore, the remaining 27 member states have a veto. Approximately 10 of them, I believe, require not just the lower house, but also the upper house to vote. That's 37. I believe there are at least 6 regions in Europe of which I'm aware of that also need to vote under the internal constitutional arrangements. So effectively, a treaty sanctioning a UK exit would have to occur within 2 years and would be subject to approximately 45 separate independent vetoes. Now, we've all conducted a large number of commercial negotiations where people are roughly rational, which is not necessarily an adjective that one would be prepared to extend to politicians. Imagine running 45 such negotiations with states involving literally hundreds of individual decisions where you have conflicting interests. So we're back to it's not going to happen within 2 years. But the decision to extend an Article 50 proceeding beyond the 2-year limit, that's also a treaty. With, again, we can have that debate, probably 45 vetoes. So the reality is, if the UK ever does, in fact, invoke Article 50, then there is, from a mechanical perspective, irrespective of the merits, a very material likelihood that Brexit, at least in an initial stage, will be a hard Brexit. Therefore, when we come back to our world of what's going to happen in insolvencies, there is some likelihood, potentially a strong likelihood, that tomorrow a British judge whose judgments are automatically recognized today in France because of the UK's membership in the EU, will become a judge from a third-party country that is not bound to France and presumably to other member states by any treaty whatsoever involving recognition of judgments, be they insolvencies, be they civil judgments, be they commercial judgments. That is likely to be one big unholy mess, and one can only hope that when they finally realize what is involved from a technical perspective, a variety of politicians will make the decision to start negotiating, assuming they do want to negotiate, outside of the framework of Article 50 rather than within the framework of Article 50.
I don't think anybody doubts the technical challenges that Brexit will cause. But perhaps I can go neutrally back to one other point that I made in relation to international insolvency. There is a world outside the European Union. We've had schemes of arrangements long before the European Union existed. We have cross-border insolvencies involving the US, involving Hong Kong, Singapore, Cayman, and the Far East in the UK because of the huge uptake of English law as a governing law for financing documents and instruments for all manner of worldwide companies. And it makes much more sense for all parties involved in insolvency to recognize cooperative judicial assistance across international borders rather than adopting a very narrow, we're in the club, you're out of the club type approach. There is the UNCITRAL model law.
With all due respect, Sir Richard, we're dealing with a worse system than that. It's not we're in the club, you're not. It's you chose to leave our club and slam the door on the way out.
But in insolvency, in insolvency matters, I think everybody probably has to recognize that there's a bigger game to play. It's the one I was talking about earlier. So that, for example, the UNCITRAL model law operates in many jurisdictions these days. It operates in America, it operates in the US, it operates in the UK, it operates in Canada, operates in Japan, and that law doesn't care whether the country from whom the insolvency comes is a model law country or not. it recognizes that it's much better in terms of coordinating international insolvency to grant recognition to a collective proceeding in a foreign jurisdiction, irrespective of whether you have any reciprocity with them, in order to achieve a better result for creditors. So yes, I don't doubt the sentiment that exists about, or would exist about, Brexit. But in insolvency matters, I think that the people in this room and the people in many rooms like it around the world probably will have to take a broader view about what insolvency actually means.
Another point I wanted to raise actually is that some of the decisions that might come from the European Union in terms of insolvency seem to emulate some things that can already be done in a very efficient way in the UK. So moving away from the politics, isn't there an argument for some jurisdictions in Europe to perhaps look at how it's done efficiently, either in the UK or in the US, and try to emulate that? I know in Spain they've set up a form of insolvency proceedings called homologation, which almost mimic what's going on in the UK as under scheme of arrangement. So moving away again from just the politics and Brexit, isn't there a common interest across Europe to make all the systems more efficient? I mean, 12 tools in France, that's a lot of tools. I'm sure they're efficient, but in terms of duration of restructuring, I mean, France doesn't rank very well. So, I mean, isn't there an argument perhaps to, instead of just saying, well, you're out of the club and I don't like you anymore, to try to learn from what's done elsewhere? And maybe not in the UK, the US also is an
Julie,
example.
it's not you're out of the club and I don't like you anymore. It's, and you've stated you don't like me anymore. That's far worse. More seriously, what you're raising is just a general argument for comparative law. As Sir Richard points out, there is a world out there outside the EU. There's always been a world out there, at least for as long as the planet has been existing. So it's always made sense to look around you and find out what other people do and see whether you can learn better things from those other jurisdictions. Frankly, French law, to take that example, is clearly an example to be learned from, because I gather Brazil has adopted a system remarkably similar to ours. And it's so far, I think, the only country that's seen the light, but there may be others out there one day. More seriously, the differences are not that substantial. At the end of the day, we all have some form of system involving a stay. At the end of the day, we all have some sort of system involving proofs of claim that enable one to determine with certainty what's owed out there and what the balance sheet actually looks like. At the end of the day, I think judges and legal systems pretty much around the world have recognized that if value is to be achieved and jobs are to be preserved, it is often better to sell whole businesses rather than sell them piecemeal in individual pieces. Now, at the end of the day, the question then becomes, and those are almost secondary questions, but they are important, who handles the process? To what extent do creditors get to control that process? To what extent, and that's the duration you're referring to, do I give companies, and from that perspective, French law is very generous, a period to stabilize their business under court protection, to carve out certain elements of it, to restructure the business before it is marketed in some way, either back to the shareholders, to the debtors, to third parties, and that's the période d'observation which we have. And those are all legitimate arguments, and you can have them in several ways. But at the end of the day, I don't think, speaking seriously for a change, we will ever stop learning from one another, and I don't think a perfect system exists.
I mean, I agree. I mean, I think we all have a lot to learn. I've been very privileged over the last year to be invited to speak about schemes of arrangement, for example, in a number of other jurisdictions, as far afield as Singapore, Japan, to Dutch insolvency lawyers, particularly recently. The Dutch, as you know, in the Netherlands are thinking very seriously about introducing something which looks very like a scheme of arrangement. and in fact, in many eyes, I think might be thought to be a considerable improvement on a scheme of arrangement in terms of the legislative structure. And I was asked to go and participate in a day-long seminar with Dutch lawyers in relation to that, which I found very valuable, because their understanding of what I did and their perceptions of what I did were actually extremely valuable to me in questioning how I approach my own cases and how I am perceived elsewhere. It may be that there are more structural problems that a lot of jurisdictions face, because one, going back to what I said a little earlier, one beauty of a scheme of arrangement is that it's a very, very flexible tool. I mean, the actual statutory provision is one sentence long. It's one sentence of English. It's in very general terms. It's been in exactly the same terms since 1872, I think it is. The beauty of the scheme of arrangement as a flexible restructuring tool is that it's administered by lawyers and judges who understand what's going on because of their commercial experience. And that is a very difficult thing to learn from another jurisdiction in a very short space of time. But I think there's great opportunity for international lawyers and jurists to talk to each other, and I think it's a great benefit. So I would certainly, I benefit from hearing what I emphasize what I said earlier. I recognize that I can only restructure a company insofar as other people recognize and respect what I'm doing. And if I hear that what I'm doing is meeting unremitting hostility in other jurisdictions, then of course I would question very hard whether I'm right to do it. So I think an interplay between jurisdictions is terribly important.